Good morning and welcome to another edition of the Waterstone Legal Update. Here with me is Damien Grant, the Director of Waterstone Insolvency. My name's William van Roosmalen. I'm one of the lawyers at Waterstone. Today we're talking about Dempsey Wood and Gapes.
Great case.
Mr. Gapes is an Auckland-based property developer and...
well-known Auckland-based property developer.
Well-known and pretty big in terms of property developers.
Yes.
This case is a very interesting one because it was brought by a creditor of a failed company.
Dempsey Wood.
Dempsey Wood, the supplier that Gapes was involved with, and the creditor has brought the claim against him directly as opposed to a liquidator. So it's an interesting perspective for us as liquidators, seeing how these director breach provisions can be used by someone other than a liquidator. There's Fair Trading Act claims in there as well, which are quite interesting. So Damien's been reading the case. I haven't, so I'm going to be asking him some questions about what went on and what's his take on the legal analysis. So tell us what happened in brief terms.
The company Panama Road Development Limited was set up a number of years ago to acquire some land in Panama Road, Mount Wellington, and it had some funding from an outfit called Crown, and that didn't go that well. Crown put in a receiver, and then a new financier, KOI, K-O-I, came and took over, and then the project continued. The whole case actually focuses on what happens in around a 2 to 3 month period at the end of 2015. So the KOI facility was running out on the 15th of October. And Gapes was in a problem because, okay, you get to the end of the middle of October, KOI was not prepared to roll the facility on. The director is sitting there saying, well, what do I do? Now, the director in this case did stuff. He wasn't sitting there like a rabbit in the headlights. One, he attempted to get KOI to roll the facility over, and in fact, after the end of the facility on the 15th of October, KOI did agree to make another series of advances, and this became critical for Gapes. KOI, though still wasn't prepared to roll over, Gapes went and got a conditional offer from another entity, Weber Capital, which was linked to the Chow brothers. Weber Capital looked at this offer, gave a conditional offer, then did some due diligence, and by around mid-November, Weber Capital came back and said, sorry, but we don't want to proceed with this. The creditor that took the case was a Dempsey Wood, which we believe is a construction firm of considerable note and scope, represented very ably by Eugene St. John, who is a friend of the show. Hello, Eugene, I'm sure he'll be watching. And Eugene and Dempsey Wood said this. They said, okay, we believe, Dempsey Wood believes, that there was a breach of Section 131, a duty to act in good faith, a breach of Section 135, reckless trading, and a breach of Section 136, which is a duty not to incur obligations. So the first question is 131, acting in good faith. Dempsey Wood says, hey, look, you're running an insolvent company, you didn't have the facilities in place. They made a number of arguments. The key thing to understand about Section 131, it is entirely subjective. What matters is, what did the director believe? Follow on from that is, was the director's belief reasonable? And so long as there was some basis for the director's belief, and the director wasn't acting irrationally, then the court's going to give the director the benefit of the doubt in Section 131. And that was the case here. Tony Gapes had done enough to convince the court that he was acting in the best interest of the company, and he had reason to believe that he was acting in the best interest of the company.
There was a period of time, though, after Sojourner and Rob, where they did impose
objective analysis
on top, and then it was the Supreme Court in Debut Holmes, was it not?
Killed it.
Said,
yeah.
Section 131, there's no writing in the section that would point towards it being objective. Correct. It's entirely subjective.
Well, no, it's not entirely subjective. If the decisions are irrational, or you can prove to the court that the director took absolutely no consideration of the interests of the creditors, then you can still get pinged for 131.
Sure.
But the standard is, you would need to show, irrationality is actually one of the terms that I think they use in debut homes, or that the director simply took no account of the interests of the creditors. But that's simply not the case here. There's no objective standard, but the director can't be acting irrationally, must have some cognizant awareness of the wishes of the directors.
It would be interesting to see how the Sojourner and Robb case influenced company directors in that 10 to 15 year period before debut homes came out, whether it was influential in case law or not.
I think it was. I think it was. I think there were a number of cases where the objective element of Sojourner and Robb was imposed, and it had to. I think Sojourner and Robb was only a High Court case. I don't think that went to the Court of Appeal, but it was certainly quoted a number of times. So 131, he got home. The attorney Gapps got home. Then we come to section 135, reckless trading. Here it gets a bit more interesting. So, was the director acting recklessly? And fairly fact-specific cases here, but it came down to this. From the 15th of October, when the facility expired, the court found that Gapps wasn't acting recklessly up until mid-November, because between the time the COI facility expired and the Weber offer was on the table, albeit not locked in, Gapps was given some leeway. And so the case, particularly in Mainzeal, has said that once a company moves to insolvency, a director is not obligated to terminate the company immediately.
No.
The directors are entitled some time to do a sober assessment, consider the interests of the creditors and see whether or not the business can be saved. And it's quite clear that Gapps was doing that. Where Gapps got into trouble and where the court says, hey, you have breached your duties, is at the end of the Weber offer. So when Weber Capital turned around and says, no, we don't want to participate, that was the point at which he was found in breach of 135, reckless trading. Similar analysis was done on section 136, the obligation not to incur debt without reasonable expectation that it could be paid. And so a similar analysis was done. There was two aspects to the Dempsey Wood claim. So they were claiming one for extension of time. So they had $200,000 worth of costs, which they said was an extension of time. Then they had another $500,000 claim, and that $500,000 claim was for the unpaid invoices that hit at the end of their job. The $200,000 claim was knocked out. So the court said at the time that Gapps incurred the obligation was back in 2013. And at that time, he wasn't in breach of any of his director's duties. And so as a consequence, at the time he made the decision to sign the contract, which had the flow on for the extension of time, he wasn't liable. Even if some of those extension of time claims fell into the period that he was trading in breach of his duties. It's important to note for this case that receivers were appointed fairly soon after the Weber facility ran out. And there was a whole pile of valuation evidence, which we won't get into, it gets a bit bogged down. The second part of the Dempsey Wood claim was their invoices that were outstanding at the end of contract, the claim and the liquidation. And the court says, okay, we're going to take at the starting point mid-November. So mid-November was the point at which the court said that Gapps was in breach of his duties under 135 and 136. He was incurring, even though he gave no instructions to Dempsey Wood beyond the mid-November, by not closing the business down when he had no realistic opportunity of funding, not closing the business down, Dempsey Wood continued to work on site and continued to incur costs. And that was the point at which the court says, hey, from the point that there was no realistic option of this company, where liquidation was inevitable, every day that went by, Gapps was incurring personal obligations. But the issue then boiled down to, well, okay, how much should Gapps be liable for? And again, they looked at causation, culpability, and duration. As is fairly common in these sorts of things where the director hasn't acted dishonestly, they've simply acted recklessly. the court came out with a finding of essentially 30 cents in the dollar. So what they did was they said you got 500,000 was your outstanding claim for Dempsey Wood. They estimated about 314,000 was cost that had occurred after the mid of November. His period of reckless trading was relatively small. They only judgment against him for only $100,000 was delivered to Mr. Gate, which was probably less than what Dempsey Wood spent on the litigation claim.
It's quite interesting because I think this is one of the first big director breach claims that's come out since Mainzeal.
Yes.
And Mainzeal had a lot of very interesting things to say. The Court of Appeal basically said that company law is currently broken in New Zealand.
They did, yes.
And that it needed to be fixed. I would imagine the underlying tone of that is that it's an urgent fix that needs to be had. We haven't seen that. This is quite a fact-specific case of director breach because, it's a property development.
We're going to see a lot more of those.
Heavily reliant on funding. It was brought by a creditor. A lot of liquidator-driven director breach claims would be looking the other way and saying, well, we've got the benefit of hindsight now. We look back and we see that the financial situation of the company was not good. Therefore, you should have stopped trading or appointed administrators.
Courts are very reluctant, though, to go back and do the hindsight tests. And there's been both in Debut Homes and Mainzeal, there was commentary about the court should be reluctant to use hindsight as the test. What did the director know at the time?
Sure.
Without, and that's hard to do, right? Because we know how the story ends. But the director at the time potentially didn't. And it's possible even in mid-November 2015, Tony Gapes didn't know how this would end. He was certainly still hoping to try and do a deal with Weber or with Coy or something, and it sounded like the receivership when it came was a surprise to him. But there's two other really interesting things that come out of this. The first is that this was a claim that was brought by the creditor. And the creditor pinged the director for breaches of director's duties and used 301 as the means by which to work out quantum. What Dempsey Wood did not do is that they didn't ask the court for the $100,000 to be paid directly to Dempsey Wood. Now, they absolutely had the right to do that, but they didn't do it in this case. And so far as we can tell, that issue has yet to be clarified. I think that the court absolutely has the right in a situation like this to pay the money directly to the creditor, but I'm not sure that we've ever seen a case where that has happened yet. Have you?
No.
And do you agree with me?
From our perspective, Mainzeal again was interesting because the court made the commentary that you don't actually need to go through Section 301. I agree with you. I think the creditor is entitled to that money.
Well, the court seems to have the discretion to do that. But until such time as we see that actually happen, I guess we're not going to have absolute clarity. It appears from what we understand of this case that it's possible that the liquidator and Dempsey Wood had come to an arrangement beforehand, so they didn't need to. But there's a corollary from this file, and that is that Dempsey Wood did not just sue for breaches of directors' duties. Dempsey Wood also sued under Section 9 of the Fair Trading Act, which is that if you are in trade, you cannot engage in deceptive and misleading conduct. And so what Dempsey Wood said here is they went back to some email communications. And so the facts are important. Coy had put about $4 million in Russell McVeigh's trust account, and that money was to be released to Tony Gap's company, PRDL, subject to quantity surveyors box ticking exercise. Dempsey Wood was getting pretty nervous and saying, hey, what's happening here? There were some email communications between Russell McVeigh, Tony Gapes, and the director of Dempsey Wood, Mr. Dempsey. And at one point, so there was an email communication came from Russell McVeigh to Tony Gapes talking about the balance of the money that was held.
This is in November.
Yep. Tony Gapes then forwards that email to the director of Dempsey Wood saying that this is the money that's there to pay for construction costs and civils and other bits and pieces. Now that email, the court found was misleading. That email induced Dempsey Wood to continue to remain working on site. So what the court said was, hold on, Tony Gates put a gloss on that email that was not necessarily what Russell McVeigh intended. And as a consequence, the director of Dempsey Wood was misled. And the argument that Dempsey Wood was saying is that they were not misled by PRDL. They were misled by Tony Gates. And as a consequence, they could ping him personally. And they did. And the analysis was really interesting. The court says, all right, we accept the argument that Gates can be held personally liable for deceptive and misleading conduct under Section 9 of the Fair Trading Act. They said the outstanding invoices that was a consequence of that conduct was $314,000. Then took off 9% for the profit margin that he estimated that Dempsey would make, and gave them an order of $286,000. And that $286,000 was to be paid directly to Dempsey Wood, not through the liquidation. And that's really interesting. The breaches of the Fair Trading Act, in some ways, for creditors, can be a more useful line of attack than breaches of directors one, because you don't necessarily have the causation, duration, culpability argument.
Yeah, it's a much more direct route, and clearly a very powerful tool. He walked away with a bigger liability from the Fair Trading Act claims than
he did.
The direct breach claims, and maybe that harks back to the Court of Appeal's comments that there's probably some reform that needs to be done in this area.
Could be.
It's not something that you would think of immediately when you're talking about director breaches, that there would be a potential Fair Trading Act breach in there as well. It's interesting because there's obviously contractual dynamics that are in play as well. Gates is going to have a contract with the financiers and also with Dempsey Wood. And so there's obviously some overlap there between the Fair Trading Act claims and the contractual arrangements, but what the court's effectively done is just taken a blanket approach and said that, well, the breach is there, you're entitled to remedy.
Yeah, and I think that's a sobering thing for directors to bear in mind, is that are you doing this in your capacity as a director of your company? Or are you doing something as an individual that somebody else can rely on what you've said? So if you do something or say something as a director and you are lying or misleading somebody, then the court may well say, I'm sorry, Mr. and Mrs. Director, you did that personally, and you can be sued personally as a consequence. And I think the other thing to point out is that the 286 judgments for the Fair Trading Act was in addition to the $100,000 for the breach of duties. So Gates ended up with a judgment of 386 plus costs.
It's a big whack.
Yeah, and all credit to the brilliant lawyering of Eugene St. John.
Absolutely.
All right.
If you've got any questions or comments, just let us know below or flick us an email. We'll see you guys next time for another update.
Thank you.
Cheers.